Good afternoon. Welcome to Long Live Third Parties podcast. Free Press Media Press Inc., a third parties books publisher, sponsors this podcast. I'm Andrew Bouchard. Today I read the case Libertarian Party of New Hampshire versus Gardner, 843 F3D20, Court of Appeals, First Circuit, 2016. Friends, we got some coalitions to talk about today, so let us talk about that. This case here involved our friends at the Libertarian Party of New Hampshire as the main backers of this litigation. Also, I love to see how there was a coalition in the amicus briefs that included number of third parties. Included the Libertarian Association of Massachusetts, the Green Rainbow Party, the United Independent Party, the Maine Green Independent Party, and the Moderate Party of Rhode Island. Way to go, coming together for this cause. This state here, New Hampshire, had a law, according to this record, that the Libertarian Party of New Hampshire did not like because it required them to start petitioning to get on the ballot earlier than they would have, started later than they would have liked. So they said it didn't give them enough time. Unfortunately, in this case, the judges do not find their arguments persuasive. They do invoke the First and 14th Amendment, and like I've been saying again and again, this comes up in these trials again and again. Ballot access trials involve the First and 14th Amendment, so I love when third parties do that. Way to go, friends. They talk about how much money is required. They say the signatures are often done by paid agencies that specialize in this type of thing. So they're arguing about whether this impacts their ability to get on the ballot. They say the Libertarian Party can do the preliminary efforts to organize ballot access campaigns before the actual ballot access starts, so they're not sympathetic. What do you think? Do you think that's valid? Do you think they should be able to gather signatures earlier? This case here cites a number of other cases. There's one with John Anderson, and there's these other third-party cases. Looks like Barr, I believe, is another third-party case. I haven't seen that case as a whole, so I'm not entirely sure what that entailed. But they do cite other third-party cases, so this is showing how the records are building on themselves. Here they talk about something I've seen many times before as well. It says, quote, endorsing state interests in avoiding overloaded ballots and frivolous candidacies, which diminish victory margins, contribute to the cost of conducting elections, confuse and frustrate voters, increase the need for burdensome runoffs, and may ultimately discourage voter participation in the electoral processes, end quote. At first glance, this seems like a persuasive argument. It would seem to make sense. You wouldn't want to have 1,000 people on the ballot. Our friends at the Green Party USA on their website and argue something very persuasive to me. They say, quote, it's a myth there are a lot of people running for office, end quote. From first-hand experience, I don't know but a handful of people I've met, and you could say I've met thousands of people over the years who have run for political office. So I would love to see that presented in a trial to counter this assertion. It would be awesome if we could question the state Secretary of State's how many people are actually trying to get on the ballot. So the Green Party has a good argument there. They do give us a consolation point. They say, quote, "Of course, we are not so naive as to reject the possibility that a state legislature dominated by the two major parties may well wish to overshoot the mark, closing the door to all competitors." End quote. It's good to see that they at least acknowledge how these laws can be misused for partisan advantage. Some people would say, no, you can't look at laws that way. The laws are completely impartial. So ultimately they say the following, quote, "With a cumulative burden well less than found acceptable in controlling precedent, and with no other attributes that themselves pose significant barriers to access, New Hampshire's regulations stand as admittedly robust but nevertheless constitutional exercises of the state's broad powers to prescribe the times, places, and manner of holding elections for senators and representatives, which powers match by state control over the election process for state office. We affirm the judgment of the District Court granting New Hampshire's motion for summary judgment in this facial challenge to part of the state's ballot access framework." End quote. Our friends didn't win. We didn't get a victory here. So what can we learn from this? How can this inspire us? Also getting back to the amicus brief, have you ever filed one of those briefs before? How did the process go? Did you do it with a lawyer, without a lawyer? I'd love to hear more about that. Let us keep marching ahead towards our goals. Long live third parties. Goodbye.